Good morning, everybody. Can you all hear me?
Yep, hear you fine.
Yeah,
That's fine. Okay. Excellent. Okay, we'll start shortly. We've got a few people still, excuse me, in the waiting room just now, so maybe another 30, 45 seconds. Okay, right. I think that's us ready to kick off. So, good morning all. Thank you very much for joining us. Where we are today is we've got the next monthly breakfast briefing for Scottish Engineering. Today it's on the topic of unfair dismissal, which is possibly the two words which strike the most fear into HR managers throughout the land, perhaps with the exception of the word discrimination. So my name's Kevin Duffy. I'm one of the solicitors here in the Scottish Engineering legal team, and I'll be talking for maybe 20, 25 minutes-ish. Then we'll take some Q&A at the end. If you want to put any questions into the chat function, I'll collate them at the end as well, or you can ask your questions verbally as well. So just to crack on, what will we be discussing today? Where we are going to discuss who can claim unfair dismissal, what actually is a dismissal itself, the reasons for dismissal as discussed in the Employment Rights Act 1996, what makes a dismissal fair or unfair, the actual legal tests that a tribunal will go through when ascertaining that, the automatically unfair dismissal aspects, what's known as constructive dismissal or constructive unfair dismissal, which you may have heard of, and then we'll have a quick discussion about how the tribunal actually makes the awards, the financial awards that can come from a finding of unfair dismissal if a claim is raised. So, who can actually claim unfair dismissal? Now, it's actually only open to certain class of person who's in a contractual relationship, namely an employee. So it cannot be, for example, a worker or a partner in a partnership or a self-employed person. Now, this employee needs 2 years service, 2 years qualifying service is the exact phrase. Now, actually, it is 2 years minus 1 week because you've got to take off the statutory notice period, which is involved as well. So 1 year, 51 weeks is what you need. Now, you can see I put a slight caveat there of see the automatically unfair dismissals. We'll come on to these later. And this is where the dismissal is for an underhand reason, shall we say, and there's no need for a length of service qualification at that particular point. And the third caveat there is that the employee must be GB based in Great Britain. Now, the reason being is that at one end of the spectrum, for example, you've got an employee who's based wholly in Great Britain. That person will definitely be protected. Then you go through the spectrum to perhaps a peripatetic employee who moves around a lot internationally. That person might be protected. At the other end of the spectrum, you've got an expatriate employee. And that person is unlikely to be protected because they're not based in Great Britain. They don't have that sufficient connection as well. So what actually is a dismissal itself? Now, actually, the first question is probably, what is a person, an employee, dismissed from? They're dismissed from a contract of employment. Now, a contract is a bilateral legal agreement that cannot unilaterally be changed by either party. However, it can be unilaterally terminated by one of the parties. So, resignation can terminate it from the employee's aspect, and dismissal can terminate it from the employer's aspect. And you can see there from the PowerPoint slide, there are 3 different categories of dismissal. The first one is basically exactly as it says on the tin, which is an expiry of a limited term contract. So, for example, we've got a project of X months or years duration, project finishes, and the employee is dismissed after that. Next one is termination by the employer, and that is actually a dismissal. And that's the bulk of what we're going to discuss today. And we'll examine this in more detail as we go along today. And the third one there is constructive dismissal. Now, this actually starts as a resignation caused by the actions of the employer, but is in law actually a dismissal. And we'll discuss that in more detail as we go along today as well. Now, you can see in the slides I put in various hyperlinks that will take you to the actual legislation and the cases that I refer to. And that's for those with perhaps a wider interest in employment law who want to do a bit more background reading on the subject as well. So all of those 3 categories, for example, come under Section 95 of the Employment Rights Act 1996. So The reasons for dismissal, as per section 98(1) of the Employment Rights Act, we've got 5 potentially fair reasons. I say potentially because whether it's fair or not depends on things like facts of the case, the process followed, and the substantive decision made. And I'll go into them a bit more detail later on as well over those 5 potentially fair reasons. Probably heard all of these 5 terms before: capability, conduct, redundancy, statutory ban, and SOSR, some other substantial reason. I'll go into all of these as we go along. So, what makes a dismissal fair or unfair? So, in the exact words of the section 98(4) of the Employment Rights Act, did the employer act reasonably? So, the question whether the dismissal is fair or unfair depends on whether, in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee, and, this is the important bit, shall be determined in accordance with equity and the substantial merits of the case. So obviously, there is quite a little bit of leeway in there for employers and employment tribunals in ascertaining this. So, tribunals often look at 2 aspects of fairness, what's known as procedural unfairness and substantive fairness. So procedural fairness, that will come from sending correct letters, organising the correct meetings, allowing the right to be accompanied, giving sufficient time for the employee to prepare for the meetings, i.e. don't give them 24 hours notice for a gross misconduct dismissal meeting, providing the evidence beforehand, having separate managers as far as possible involved in the investigation, dismissal, appeal decisions, stuff like that. Now, this very famous employment law case here, Polkey versus AE Dating Services, stressed the no difference rule. Basically, you have to have correct procedure. What an employer cannot argue is that the employee would have been dismissed anyway if you'd followed the correct procedure. However, this may impact upon the awards given to the employee later in the case, however. Now, there's also the ACAS code. Again, this stresses good procedure, so meetings, documents, representation. Now, the ACAS code only specifically applies to capability and conduct dismissals, possibly SOSR dismissals as well. There are separate rules and regulations for redundancy dismissals, for example, as well. And substantive fairness, harking back to the Iceland Frozen Foods versus Jones case, that discussed, again, another very famous employment law phrase, which is the band of reasonable responses. The tribunal has to decide whether the employer's decision to dismiss the employee falls within the band of reasonable responses that a reasonable employer in those circumstances and in that business might have adopted. Now, it's not for the tribunal to substitute its own views for that of the employer. What that means in reality is that in any given set of circumstances, say, a less harsh employer might take a more lenient approach and give, for example, a written warning or a final written warning. However, at the other end of the spectrum, at the other end of the band of reasonable responses, a sterner employer may not be as lenient and may actually dismiss for those same set of circumstances. However, so long as a decision falls within the band of reasonable responses, it will be fair. So, how do we apply these rules and guidelines for reasonableness and fairness to these 5 potentially fair reasons? As we say, capability all the way through to SOSR. Now, these will be different because the process and decisions that an employer makes in a conduct case will not be relevant to a redundancy case as well. So, for capability can relate to the ability or the qualifications or the health of an employee. So, in relation to somebody not performing and not hitting their targets, did the employer set clear goals and timescales? Did they give the employee sufficient training? Were there regular appraisals? Did the employee get warnings if they were not hitting those goals and timescales? Because what an employer shouldn't be doing is springing any surprises on an employee when it comes to a dismissal, for example. The employee should know what they're being dismissed for when it comes to that dismissal meeting. So there should be, shall we say, an audit trail of history of what the person has been doing wrong or not doing right through their time with the company. Now, in relation to somebody being incapable regarding health, being basically too ill to carry out their role, did the employer carry out any medical investigation? Was there any occupational health provided, for example? What's the length of the illness? What type of illness is it as well? i.e., what impact does it actually have on their ability to do the job? Now, obviously, be wary of disability discrimination. For example, has the company made all or reasonable adjustments required by the Equality Act 2010 to allow somebody with long-term health issues to do their job? Now, conduct dismissal. Now, we all know conduct is short for misconduct, because nobody ever gets sacked for doing something correctly. They do get sacked for doing something wrong, for an act of misconduct. So, as per this, another very famous employment law case, the British Home Stores versus Birchall, what the employer has to do is investigate the conduct. The investigation is key. So what this Birchall test says is, at the time of the dismissal, the employer believed the employee to be guilty of misconduct. The employer, excuse me, had reasonable grounds for believing that the employee was guilty of that misconduct and, importantly, had carried out as much investigation as was reasonable in the circumstances. So, on a practical note, did the employer interview witnesses, take statements, view CCTV, hold investigatory meetings with the employee to allow them to put their side of the story forward? And as I mentioned before, employment tribunals take a very dim view of fait accompli being presented to employees. Now, an investigation is not just to get the employee bang to rights. It's an exercise to find out the facts of the case, facts that may show the employee is not guilty of the misconduct, and legalese, did it show any exculpatory evidence? So, it is a reasonable investigation that the employer has to go through, not a police-level criminal investigation to a forensic level of detail. Now, for redundancy, what an employment tribunal would look for in reasonableness for a redundancy situation is, number one, a sound business case. Why did the employer no longer need this particular employee? Thereafter, did the employer put the employees at risk? And thereafter consider who is in the pool of employees as well. Also, did the employer carry out a consultation exercise, a thorough and reasonable consultation exercise, to discuss with the employees if there are any ways to mitigate or avoid need for redundancy? And if you'd have that pool of employees, what selection and scoring mechanism did you apply to the employees to decide who's staying and who's going? And also, a very important aspect of consultation is, did the employer look at suitable alternative vacancies? However, if, for example, a cleaner is at risk within the organisation and there's a vacancy in the chief executive role, that's unlikely to be a suitable alternative vacancies. But also, employers need to look beyond job titles to see if there are any transferable skills to move people from one particular role into a suitable alternative vacancy that on the surface didn't superficially look like suitable and alternative. Now, statutory ban. The full Sunday wording of this is that it's for the employer to show that the employee could not continue to work in the position that he held without contravention, either on his part or on the part of his employer, of a duty or restriction imposed by or under an enactment. So a common example is the loss of a driving licence for a driver. Okay. Generally, that would mean that the employee loses their job because they will no longer drive. However, things that you have to take into account is the extent of the statutory restriction on the employee's ability to do his or her job, the duration of the ban, and consider the potential differences between, say, a 3-month restriction on certain aspects of the role as opposed to a lifelong ban on all aspects of the role. One is going to be more fair to dismiss than other. And are there any alternatives to dismissal? For example, again, if it's a shorter, less onerous restriction, can any alternative duties be put in place for the duration of the restriction or ban? For example, can we use up any annual leave or put in place any unpaid leave as well? Again, employment tribunals are very keen for employers to investigate the non-nuclear option, i.e. look at non-dismissal options in any particular situation. Okay, and the final reason is SOSR, some other substantial reason. Now, there are various different aspects of this, or various different SOSR reasons that can be fit under that particular heading. For example, there's what's known as third-party pressure, and that's where a client of the employer says, get this person off my site for whatever reason. Now, again, that's a very strong indicator towards there being a potential dismissal. However, you can't just take that as read. The employer needs to carry out a number of other actions. For example, can they look at any alternative roles or any alternative sites to put the person to? Can't just sack the person straight off. And depending on the circumstances, it might be incumbent on the employer to try and ask the client to reconsider the decision. client might not do so, but the fact that the employer has asked will strengthen the fairness of any ultimate dismissal. Now, here is a recent case that's came out for the Employment Tribunal of Kubulis versus Kent Food Limited. This is COVID-19 related, excuse me again. This is where a delivery driver refused to wear a face mask on a client site. So the client banned them. There were no other roles for the employee, and thereafter he was sacked. Now, the Employment Tribunal looked at this and said that this could have been either a conduct dismissal or an SOSR third-party dismissal. The ET decided the underlying refusal of the employee, brackets combined with a complete lack of remorse from the employee during the disciplinary process, was a conduct issue in its own right, and that was held to be fair. But there were very much large SOSR third-party pressure aspects of this as well. Another aspect of SOSR is what's known as fire and rehire. Excuse me, sorry. I'm going all the way wrong here. Fire and rehire. So again, you're looking at investigation and consultation here. And are there any ways to try and get the employee to agree to the new terms and conditions? Are there any sweeteners you can put in place? Can you try and come and go on any of the more controversial aspects of the terms and conditions? Importantly, did you give warning to the employee that dismissal might be an outcome from their continued refusal to accept the new terms and conditions? And also during the consultation, did you give the employee an opportunity to state their case of why the new terms and conditions are perhaps not suitable to them? And again, at one end of the spectrum, you may have somebody who has health issues or family issues or travel issues, who has bona fide reasons for not wanting to go through to the new terms and conditions, as opposed to somebody at the other end of the spectrum who's just saying, I'm not doing it because I'm intransigent and I don't like it. One end is going to be fairer to dismiss, the other one might not be. However, when balancing the needs of the employer and the employee, unlike what some trade union reps think, it doesn't have to be a life or death situation for the company to impose these new terms and conditions. There merely has to be a sound business reason for them. Now, moving on to the automatically unfair dismissal aspect now. As I mentioned earlier, this is where the employee is dismissed for what's known as an underhand reason. There's no need for that 2 years qualifying service. So say, for example, you've got somebody who is on their first week of employment and reports something is unsafe in the workplace, and the employer very foolishly dismisses the person with short service for that reporting of health and safety matters straight off. That's likely, highly likely to be an automatically unfair dismissal. Now, overall, this is where the dismissal flows from something the employee has reported to the employer, or in certain circumstances reported it to another party. There has to be a causal connection between the employee action and the subsequent dismissal. So for some example, underhand reasons, a protected disclosure in layman's terms, whistleblowing. This covers things like where there's a legal obligation being breached, miscarriage of justice occurring, or damage to the environment. What the test says in section 103A of the ERA is, an employee who is dismissed shall be regarded for the purposes of this part of the Act as being unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal is that the employee made a protected disclosure. So if there are a number of reasons for dismissal and the principal reason for the dismissal is the whistleblowing aspect, then that will be automatically unfair. Another aspect of automatic unfair dismissal is asserting a statutory right. So say, for example, an employee raises an issue about not being paid a national minimum wage or not getting their annual leave or some other form of leave, like paternity leave or maternity leave. If somebody raises an issue about such a statutory thing with the employer about this and is sacked due to it, and that is the principal reason for the dismissal, then that's automatically unfair, irrespective of the employee's length of service. And final aspect there is raising a health and safety issue. Now, another recent case, which is Rogers versus the Leeds Laser Cutting Limited, COVID-19 related. This is a case where an employee with less than 2 years length of service went on unauthorised absence and became basically incommunicado. He was sacked. Now, he tried to say that he'd previously complained about workplace being unsafe due to COVID, and that was why he'd been dismissed. However, there was no evidence of such complaints and no evidence, in fact, of any lack of safety in the workplace, and with the employer having taken reasonable COVID precautions and preventative steps. The dismissal was found to be not automatically unfair because there was no causal connection between a reporting of wrongdoing by the employee, which thereafter caused the dismissal. Now, These two cases, the Rogers case and the Kaboulis case, are useful for employers as they perhaps give an indication of the direction of travel of the employment tribunal judges, i.e. that they may be sympathetic to employers who are battling through a difficult time. However, there are two caveats to that. Number one, these two decisions are what's known as first instance decisions by the employment tribunal only. The employment tribunal is a lower end tribunal, so it's not by one of the higher courts like the employment appeal tribunal, the Court of Session, or the Supreme Court. So therefore, these tribunal decisions are not binding on future tribunals. And importantly, each employment tribunal case turns on its own facts. So just because you have somebody who has been banned by a client from a site doesn't mean to say you can automatically follow what happened in the Kaboulis case, for example. Each case turns on its own facts. Now, constructive dismissal. Now, you remember from slide 4, there are 3 types of dismissal. Number 1, the non-renewal of limited term contracts. Number 2, dismissal by the employer. And number 3, constructive dismissal. This is the third. This is a very specific definition under section 95(1) of the Employment Rights Act. And that is where the employee terminates the contract under which he is employed with or without notice, i.e. he resigns, in circumstances in which he is entitled to terminate it without notice by reason of the employer's conduct. Now, the factors required for this are a repudiatory breach by the employer of an express or implied term of the contract. Now, repudiatory is legalese for fundamental or major breach of the contract. The employee resigns in response to that breach, i.e. doesn't resign for another reason, and there is no unreasonable delay before resigning. Otherwise, there is what's known as possible affirmation of the contract. And that's another way of saying that the employee, by not resigning and continuing to work under the contract, says that they are basically accepting of the employer's actions. Now, the burden of proof in a constructive dismissal case is on the employer, on the employee to prove that there has been a fundamental breach. So it's a slightly easier case for an employer to defend. Now, if all goes horribly wrong, unfortunately, you're taken to an employment tribunal and you lose, the employment tribunal can make a number of financial awards, and they're under a number of different subheadings as well. The 2 main ones are what's known as a basic award. Now, that's calculated much like a redundancy payment, which is based on age and length of service. So an employee who is older and who's got longer length of service will get a higher basic award than a younger employee who's got a shorter length of service as well. And on the compensatory award front, that's a multiple of the net weekly wage, basically, to work out what the financial loss of the employee has been by reason of the dismissal. Now, that's capped at a year's pay or 89,493, whatever is the lower as well. And you remember earlier on, I mentioned the ACAS code. For an unreasonable refusal of the ACAS code, either by the employee or the employer, there can be an uplift or a down playing of the awards by 25% or up to 25% for the breach of the ACAS code as well. Now, there are a number of possible reductions an employment tribunal can apply to these awards once they have awarded them. Polke award, as it's known as, and that refers back to that Polke case earlier on. This is where the employer can argue successful that the employee would have been dismissed anyway, but for the procedural fault in the dismissal process. So say, for example, the tribunal felt you should have given the employee a few days longer for the for the dismissal hearing. The employer may only have to pay a percentage of the unfair dismissal awards in that case. Contributory conduct is the next bullet point here. And this is where the dismissal itself is unfair, but the employee, him or herself, is not without blame. They have somehow contributed to their own dismissal by their own conduct. Fail to mitigate loss is the next one here. And this is where there is a duty on an employee, an unfairly dismissed employee, to look for a new job to mitigate the financial loss that they have suffered. So basically, they can't just sit around watching daytime TV all day. They must look for a new job and be seen to have done so. Now, importantly, on this last point here, regardless if one or more of these factors reduce the award, sometimes even by 100%, it is still an underlying finding of unfair dismissal against the employer. That's an important aspect to remember. Also, an employment tribunal can order reinstatement of the employee to their old role, or the re-engagement of the employee back to the company, but in some other role. But these remedies for the employment tribunal are relatively uncommon. By far, the most common remedy for the employment tribunal is to make awards, financial awards. So that was very much a whirlwind tour of unfair dismissal. Don't see any chat questions as yet. I'm happy to take any verbal questions just now, or you've got my contact details. I can email me through anything that you see fit as well. So folks, over to yourself. Have I stunned you all into silence? What I'll do, if there are no further questions just now, I'll email out a recording of today's breakfast briefing and copies of the slides as well. And if that piques any interest or causes you to think of any questions further on down the line, feel free to email me at any point or give me a call.
Kevin, it's Rodney. Can you hear me?
I can indeed, Rodney. How are you this
Kevin,
morning?
a quick question. Have you seen anything coming through with regards to non-compliance in the company to any of the COVID rules, conditions, mask wearing, face covering wearing that you've had to deal with?
I have a couple of cases just now of employees who are alleging that they have been dismissed for not carrying out the company's rules and regulations regarding COVID. I also have people who have been dismissed for bona fide conduct reasons. One guy in particular who was effing and blinding his supervisor, who is now subsequently trying to say that he was dismissed for raising the health and safety issues. So apart from the cases which I mentioned earlier on, the Kabulis case and the Rogers case, none of them have actually made it through the tribunals here. They're still in the process of being decided upon, Rodney. But it's certainly a route of attack by trade union reps and employees, most certainly.
Thanks, Kevin.
Okay, any further questions? Okay, guys, right, we'll knock it on the heads there and I'll send out that information to you later on. I hope you have a good day. Cheers now, take care.
Okay.
Thank you.
Thank you.
Thank you. Bye.
Bye.
Thank you. Bye.